Thank you, Janet, and good morning, ladies and gentlemen, our distinguished colleagues uh, who serve with me and have served with me in the government, and the scholars, practitioners, and others who've joined us today. We are here to discuss an extremely important part of my office's work to preserve the public's trust in nonprofits, and not incidentally, to protect New Yorkers from fraud and deception and defend our democratic process. Your presence here reflects a commitment to these goals, and my staff and I are grateful for your participation. As Janet mentioned, I proposed new regulations last month to require the disclosure of expenditure and donor information by nonprofits that are active in elections. We are enacting these rules under the authority granted to the New York State Attorney General by New York's executive law and by our state's powers and trusts law. These regulations, we believe, represent an important step towards clarifying issues that today confound many New Yorkers and many involved in the political process. We are seeking to provide transparency and to ensure the integrity of New York's elections. Last spring, an investigation into the conduct of not-for-profits, and we immediately became aware that there was widespread abuse of the not-for-profit form by people and entities seeking to engage in political activity. I was encouraged that this was an area ripe for inquiry when on September 24th of last year I received a letter from Senator Orrin Hatch, the ranking member of the U.S. Senate Finance Committee, and Representative David Camp, the chairman of the House Committee on Ways and Means, telling me, among other things, we request that your office cease its efforts to obtain tax returns and tax information from these groups. I sent them back a nice letter explaining the federalist system, and we've continued our inquiries, and the regulations that we have proposed are a critical part of this process. Last November, we got a glimpse of what can happen when nonprofits that conceal the identity of their donors invade our electoral process. We know that between $400 and $500 million flooded into the American political system without any way to know who was behind it. As we begin the new year, most of us, and I'm sure most people in the United States, would agree that what is now referred to as dark money was an unwelcome influence in the recently completed campaign cycle, and we are here today to say, not in New York State. It's very important that everyone recognize that the greatest harm that can be done under the current system is not in a presidential election. Under the Supreme Court's rulings in Citizens United and in a subsequent case involving the state of Montana, unlimited amounts can now be spent in local and state elections. We are talking about the ability to intervene in district attorney races, in judicial elections, and of interest to some here, mayoral races. The problem is compounded by the issue we're addressing today. At least under Citizens United, you're supposed to know who is paying for ads. The abuse of 501c4s has permitted us from receiving that benefit and prevented New Yorkers from understanding who is paying for what and who is supporting what candidate. My staff and I recognize that making policy in this area is serious business and that it's critical we get every detail right. The proposed regulations are the product of months of careful work by attorneys in my office, including some on the panel today, but we, in our efforts to seek to balance the need to bring greater transparency to donors and the public, we are also seeking to address the needs of legitimate nonprofits and the rights of donors. We are here seeking comments because as good as the draft regulations are, we hope that we can make them even better through this process, and today's hearing is the first of 4 that we expect to hold around the state. I'm certain that the witnesses who will testify are going to give us crucial feedback, and people can also share their thoughts with us by visiting our website and submitting comments in writing. The website is www.ag.ny.gov, and if you click on Charity Disclosure Regulations, you can have your comments reviewed by my office as well. I am very grateful that some of my colleagues in government have taken time from their busy schedules to join us today, and we will be hearing from Public Advocate Bill de Blasio, City Council Speaker Christine Quinn, who I recall working with on campaign finance issues back in 1998, and former Controller Bill Thompson, all important voices for reform, and I welcome your participation. I also want to thank the leading reformers, good government advocates, scholars, and legal practitioners who are here and taking their time to help us with this project. It is tremendously important to get the regs right, and it is terribly important to educate the public about this effort as we go forward, because I have a nagging suspicion that we will be challenged in court. In a moment, I'm going to turn this back over to Janet Sable, my Executive Deputy Attorney General for Social Justice, but I wanted to first make one statement to put this set of regulations and our work in this area in context. Our regs are only one part of an overall strategy to address the issue of money in politics. The dramatic changes in election spending that the Supreme Court invited in Citizens United and the subsequent case regarding state laws, which struck down Montana's 100-year-old system of regulating contributions, demand that we take action on three separate fronts. First, we need to develop a long-term strategy to address unregulated flows of money into the political process. New Yorkers, like all Americans, need to have faith in their government and their elected leaders. This means stopping corruption and, in the words of Justice Kennedy, the appearance of corruption that comes from unregulated political cash. Let me be clear and even a little blunt. We need to create a record for a successful effort to overturn the Citizens United decision. That will not happen this year or next year, but if we do our work, I'm confident that it will come to pass. Second, we must demand total transparency while we set that record. We have to have full knowledge and disclosure of where campaign cash comes from and what it's spent on. That's the goal of these regulations, and we are looking forward to collaborating with our colleagues at the federal level on addressing federal campaigns as well. Because of the preemption doctrine, we cannot address them through the Attorney General's office. We can address New York State and local campaigns, and this year, obviously, that's of tremendous importance. Finally, the third prong of the strategy is that we need to expand public campaign financing systems like the successful program here in New York City. The Supreme Court has made it hard to lower the ceiling on expenditures, but we can raise the floor with public financing and give all candidates a chance to compete. I know that most of our colleagues in Albany, most members of the state legislature and the governor favor this. Let us work to see that it comes to pass this year. In closing, thank you for being here. Thank you for your commitment to these issues and for helping us to make full disclosure the norm in New York State. And with that, I want to turn things over to Janet Sable